So it's time to get started. I'm Dr. Arlen Myers. I'm President and CEO of the Society of Physician Entrepreneurs and part of MI10 with my partner in arms, Dr. Anthony Chang. Anthony, welcome.
Thank you, everyone, for coming today for our sort of ongoing series on clinical career, clinician strategies with different alternative careers or just dimensions of your career that will, I think, really help to decrease the likelihood of burnout, which I think our guest, Lisa, may not know, but about a quarter to a third of clinicians are seriously considering leaving healthcare. And it's just very devastating, kind of exaggerated by the pandemic. So welcome, everybody.
And I'm pleased to introduce Lisa Curtis. Lisa, do you want to tell us a few words about yourself?
Sure. I actually just got off the Citizens Redistricting Committee for my state. So I seem to do a lot of that introducing. It usually starts out with, hi, I'm Lisa Curtis. I'm a mother of 4, grandmother of 3. But I am a 29-year trial lawyer. I do medical malpractice work. I only represent the patient. I have the honor of working in New Mexico. I do work in other states also, but frankly, we're so busy, it's not only not necessary, but takes time away from my practice to go out of state. I hire experts. I have every single day for every single case. And in fact, I have a vascular surgeon named Dr. Harwards giving his deposition in about an hour in one of my cases here. And I know Dr. Chang because he is a hotly sought after expert and and really stellar pediatric cardiologist. And so gotten to know Anthony quite well, and he called me and asked me to talk to you guys a little bit about being experts.
Great. Did you say he was a hot expert or a hotly sought after expert?
Hotly sought after, although I'm sure he wishes I said hot.
All right.
I'm sure that's
so
true. Married woman, I see that differently.
Right. So Bill, thanks. I want to just shout out to Bill Sobers, who has graciously agreed to be one of our sponsors. Bill, do you want to give a two cents about yourself?
Sure. Thanks, Arlen. I'm Bill Sobers. I'm with UBS Financial Services, based in Phoenix, Arizona. Also a co-lead for the Arizona Society of Physician Entrepreneurs chapter. I work a lot with physician entrepreneurs, rural hospitals. Most of my work is in healthcare, and so that's me.
Great. Thanks again. All right. So without further ado, Anthony, take it away.
Yeah, I thought we just have a live Q&A with Lisa. She's so well sort of experienced and knowledgeable in this area. So I think the framework here is not only sort of have potentially, as Arlen would say, a side gig in medical legal work, but also just for a clinician to understand medical legal issues in general. So this is sort of a dual purpose session with Lisa. And thank you again, Lisa, for coming in. Thank you, Bill, for sponsoring the series so that we have clinicians really have benefit from the discussion. So Lisa, welcome, first of all. Coming down to the medical, well, let's start with definitions, and I think you're so good at them. What would be a good malpractice case for you on either side?
Yeah, so the phrase I usually tell my clients is it's a terrible thing to have a great case. All right, so a great case is most of my clients have died from malpractice, probably about 80% of my clients, and that very severe damage. And then while medicine is, incredibly complicated, when I look at a case, I can tell the parents or the family, they know something's wrong. And then we pick out one of you that's a very highly qualified expert in your specific area. And that doctor tells me if something went wrong. And so that's true for both sides of the case. Many times, as Anthony knows, my husband was a defense lawyer for malpractice cases. He retired about a year ago. We did the same thing. We took a look at what the care was with a highly qualified expert, and we knew from the very beginning he did as well as I did, whether there was a case or not, because a physician is who tells us whether something went wrong. Lawyers can't do that.
What do you think, Lisa, is the number one, number two elements of the case that you've seen that physicians just could have done better?
Yeah, so we see a lot of general surgery cases. I'm just telling you. Okay, we see a lot of general surgery cases, and a lot of that's driven by RVU payments. People doing cases that maybe they shouldn't be doing, since for-profit healthcare systems have gone a lot more to paying surgeons based on how much surgery they do. That's been a problem. One of the other things that we've seen are really heavily sepsis problems, where I don't know if it's confusion in the industry or not following EMR issues, but people that aren't treating sepsis, which, as you all know, can be very fatal. And so it creates a very big damage in a patient where some pretty well-known standard of care issues aren't followed. And so we're seeing a lot of those kinds of cases in particular.
How about universally, what kinds of things that physicians do you think would be setting themselves up for a potential medical legal case? Because that's one of the most often questions I get from doctors that want to sort of consider this line of work or just become more knowledgeable about medical legal issues.
Sure. We know there are certain categories of things that get people into trouble. Age, young or old, okay, divorce, where people aren't able to really practice medicine at the level that they would expect of themselves. Or we have, in reality, it's not a whole lot different than what you see in criminal work. We have frequent flyers, people that get into trouble all the time, but will not get, but aren't fired. For doctors, what we see is when I don't want to sound like I'm dumping on corporations all the time, but I mean, when you have a for-profit healthcare system and they're demanding things out of physicians, it drives us crazy because you guys have all the power. You can say we will do or we won't do, but somehow the medical corporations are forcing, this really substandard care, taking the double checks out of the medical system, so that things that would have gotten picked up, 10 years ago aren't. And so what we're really seeing is that kind of forced, almost kind of assembly line medicine, and that gets a lot of doctors in trouble.
Yeah.
That more than probably anything else.
How about communication skills for physicians? That comes up occasionally. Even if a mistake was made that the physician never told the family anything, never mind just a hint of something, but nothing. I think that sometimes get physicians in trouble.
Absolutely. Communication is critical. I mean, I can't tell you, I turn down about 300 cases a year. And many of those cases are simply because the physician would not talk to the patient's family or the patient after something bad happened. And talking to your patient, I mean, it's well known, and I know Anthony knows this, if you made a mistake, okay, if you did something wrong, taking responsibility is almost always what the patient wants. They just want to know they're not crazy, something bad happened, I knew there was a problem, and then they want to know that you're going to try to fix it so it doesn't happen again. All right, because they don't really, being in a lawsuit for 3 years is about the last thing they want to do when someone's died.
I'm always amazed, Lisa, how forgiving families are when you kind of just say, this wasn't what we had in mind in terms of what happened, and unfortunately this happened, and we could have done this a little bit better. And they're so amazingly forgiving. I just can't emphasize that. It's just to make how forgiving they are if you're honest with them and integrity is there. If you're hiding something and they found out, that's like a perfect recipe.
Oh, it is.
Also listening, right, Lisa? Listening is something that physicians who are, as you said, stressed by the environment we're in, don't do enough of, and that's also another recipe for a disaster.
Right. I mean, many times what we're seeing with that assembly medicine I was talking about is people not taking a good history. I mean, it's very basic, but if they listen to the patient and what they had to say, or if a patient's not talking to you, right, because they're an elderly person and they don't want to bother you, okay, because that they feel like you're in a hurry. Oh, I don't want to bother you. If you take a few minutes and you actually take the good history, I cannot tell you how much that would mean many times, not only in not making the mistake, but if you did, that the patient felt like, well, my doctor cared about me.
Mm-hmm.
I know they didn't mean to do that. They cared about me from the beginning. So the communication thing actually has a significant impact on the other end sometimes. If something went wrong, if you listen to them to begin with, then you tell them, we tried everything we could, but we something went wrong and we're so sorry about that. But not the I'm sorry this happened to you. Okay, because that one really goes backwards.
Yeah.
The not apology. That is the perfect storm for patients, just so you know.
So communicating important issues, listening, and particularly, I think, and this, I remember one or two cases that we were working on together, when a family member is repeatedly saying something or asking you to do something and you're not responsive, I think then they start to get a little bit bitter, and that's sort of just grows as that goes on. So, no matter how sort of unreasonable you think maybe something that's being said or something being suggested, you have to be, I think a clinician has to have empathy and understand why they're insisting on something. And I think that's a characteristic that I see in a lot of cases, is just the families feel like the clinician's not spending enough time with them to understand something that's very important to the family, taking care of the patients.
That's right. There's an example I can give you on a case. I had 100 clients with 5 other firms because a doctor was experimenting, putting polymethyl methacrylate in the disc space. All right, of a bunch of vets down at one of our air bases. And, you're not allowed to do that, all right, because it just extrudes down into the disc space. He said he had all these certifications, that he was a neurosurgeon in Europe. He was really good at communicating with his clients, really, really good. When the hospital finally fired him, okay, for experimenting on the patients, he made a caulking gun in a machine shop and used it for this purpose. Okay, I mean, it was not even a question. The patients fought not to get him fired.
Yeah.
Okay, because he was such a good communicator. I mean, it took a while to undo that, but that's how important communication actually is, I think, between physicians and patients.
So communication, empathy, and listening to your families that we tend not to do. Arlen, did you have a comment or question?
Yeah, I want to preface my question with just some background. I've been sued twice. I'm an ear, nose, and throat surgeon, Lisa. I've been sued twice. Both of them were, and we can get into the details, both of them were settled. 2, my observation is that most doctors get sued for things they shouldn't be sued for, and they don't get sued for things they should be sued for. 3, I have personally, and I don't do it anymore because in most jurisdictions you have to be an active practitioner. But when I was an active practitioner, I was pretty involved in med mal and product liability. Now, my understanding is you don't deal with product liability, but it might be useful to describe the difference. And I was an expert. I was a defense and plaintiff's witness on both sides. So it brings up a couple, and oh, by the way, my father died in the ICU following heart surgery, and I'm not sure whether actually that was an error or not. Now, this was a long time ago. So I have a professional and personal interest in doing this. So with that background, my question is, there's several. One is this issue of the I'm sorry movement. Now, back in the day, when you made a mistake, or something went south, and of course, most surgeons don't think they made a mistake. It just, things went south. Mm-hmm. The recommendation at the time was, number one, document, document, document. And if you don't document correctly, or you lie in the operative note, it's going to come back to haunt you. So document objectively. Do not use emotional words. Do not get crazy in those days dictating. Document what happened. Number two, call risk management. Mm-hmm. And you pick up, and I had maybe it's fortunate or unfortunate, I had an ongoing relationship with the risk manager at my hospital, and I'd pick up the phone and she'd, oh, Arlen, it's you again, what happened? So you tell them what happened to tee it up, because then what happens is patients get angry because they start getting billed for stuff and they're pissed off. Mm-hmm. So the question really is, that changed several years ago. It wasn't protect, it was admit. In other words, and the acronym is ACT. Acknowledge your mistake, contrition, which is the C, which is I'm sorry. And three, to your point, I'm really sorry this happened, but you can't get into the system's issues, and because it's just over their head. And they're not listening to what you're saying. The patients are angry and they're not listening to what you're saying. So attempting to explain to them what happened in the system, like, we're sorry, but the CT scan was put on the viewing box in the OR backwards. So the neurosurgeon operated on the wrong side of your father's brain. That's just too hard to wrap your head around. They're not interested in what happened. They just want to know that you're going to do something to fix the system. So my question is it still evidence-based that the I'm sorry movement has removed malpractice or lessened malpractice litigation?
So I think that risk management usually won't allow the things that you're talking about, Arlen, at least what I see. I see a lot of circling the wagons. I see a lot of altering records, almost every case. So everything has gone away from the document objectively what happened, talk to your patient and say, I'm really sorry, there was a mistake made. And I'm going to make sure that there are policy changes so that doesn't happen anymore. That's when we didn't get those cases. Okay, I mean, we didn't get those cases if the doctors did that. But I mean, I've got a case right now that they are going to pay me 8 figures in because they lied in the records in 2 places. All right, I mean, flat out lied and said they did things they didn't do. And the problem is, and the thing that I don't think physicians understand all the time, is that you've got nurses that are documenting. I have a nurse practitioner that works in my office, okay, that goes through and puts every single thing together so I know what happened in what order. All right, so whenever anybody alters those records, I'm gonna know it. Okay, I'm gonna know it because other things won't make sense with that. All right, so that is a really good question, Arlen, because in the old days when that happened, we didn't see those cases. But I really think it comes from like an integrity place. You know, if Anthony does something that's wrong, Anthony's going to go in and talk to that patient, and 9 times out of 10, and hopefully there's only 10 errors in his entire career, so only has to do that. 10 times, but 9 times out of 10, nobody's going to see you. It's when the patient's got really serious lifelong problems that if the hospital doesn't get in to try to take care of that pre-suit, then there's going to be a lawsuit because they don't have any other way to take care of their child, or in Anthony's case, for the kind of patient he's got. So
what I'm, and I don't want to tie up the conversation, but one final point. So what I'm hearing you say, though, is if you're honest, it's more likely you're going to get sued.
No, it's exactly the opposite. If you're honest, it's less likely you're sued. And if you're sued and you're honest, your award's going to be way down here. Okay, when you lie, then that award is I mean, that is where things get really bad for people. Where there are big, huge, nasty awards against people. It's almost always related to somebody in the system lying.
Yeah, so integrity is, even if it's not comfortable or something that you really viscerally don't want to do, you're still better off being entirely honest and admit to that. I know it's hard for clinicians because we're trained not to make mistakes, cover
Right.
mistakes if you can in M&Ms, but it's really, really deadly if you do that, especially, as Lisa said, if you're lying. And I think also, I think your comment about documentation by nurses is so spot on, because my colleagues, when I was more active in the ICU setting, used to tease me because I read nurses' notes, and not just because it's good for me to get more intelligence about what's happening with the patient, but also sort of real-time correct things that are obviously not correct. And I wasn't really thinking of it in the medical legal sense, but more in the sense that I want accurate documentation. So I know that's something that clinicians typically aren't taught or trained to do, but reading nurses' notes, really, you get a lot of dividends from reading nurses' notes. I want to get into, because I know some of the people with us today are interested in getting into this line of work. Mm-hmm. And so I want to get into those quick questions for you, Lisa, because I know these are easy questions for you. What is good and not good about being in this line of work? Well, first of all, just so everyone has clarity, there's a difference between, I think, a medical legal consultant versus a medical legal expert witness, because there's overlap, but it's not exactly the same. So you can do consulting work without being an expert witness, which is sometimes stressful for certain clinicians. So we'll focus more on the expert witness work that you work, because you work with so many experts. What is good about this work and what's not so good, in your opinion, from the lawyer perspective?
Sure. I mean, it's interesting. The word that you were using earlier is a very important one, and that is integrity. If an expert has integrity, they can take a cross-examination. Okay. Mm-hmm. All right. This is which everybody can do, and Anthony could give lessons to every single person on here about how to do that, because the doctor is always smarter than the lawyer about the medicine. Okay. But if you try to get into a fight, an argument with a lawyer, that part we do for a living. Okay. So the understanding with integrity, your area. And I think what's really great, my experts that I love, who are the best trained doctors in the best institutions in this country. Okay. They care about the patient first and foremost, right? They care about the patient and they care about the integrity of their profession. They want to make sure that, and if they take it from that avenue, then they are unbeatable. Okay. I mean, they cannot be beaten by a defense attorney because that is their perspective. They're there for the patient and they have integrity and they care about the profession. All right. The guys that we murder, okay, are the guys that will not tell you how much they make as experts. They hide information. They only work for the defense. All right, because they're there for the doctor. They're not there for the patient. And the worst thing to ever do, ever do, is do not be on duty while giving a deposition, which actually happened to me about a month ago. All right. And where the guy was supposed to be taking care of patients, but he's giving a deposition to me at the same time. I called the depot because it wasn't safe for his patients. Okay, so the idea of how you approach this work is important. The other thing is you need to know who you're working with. You know, sometimes doctors just look at the case, which would be great, except that if they don't have a lawyer that has integrity, they're going to get in trouble. All right, because they won't have the information they need to make a decision. You know, I mean, they won't be protected in the environment, okay, in the deposition or whatever. So good expert witnesses will always check out who the lawyer is that they're talking to start with. Okay, because that really matters. You want to be with a credible attorney who knows what they're doing. You shouldn't have to get retainers, but when you first start out, I'm shocked that anybody is dumb enough not to pay an expert witness. Okay, but it happens.
Yeah.
And so that retainer is a reasonable thing to ask for the time that you spend doing the initial review. All right, because if you're going to give an opinion that has integrity, okay, like if I ask Anthony, would you take a look at this case? And he says, you know, Lisa, I see why you thought there might be something here, but no, this congenital problem causes exactly this outcome. You know, this was a definite risk of the surgery. There's no case here. I say, okay, Anthony, I'm not going to bring that case. All right, but I would always pay Anthony for his very valuable time in doing that work. All right, but the retainer takes the stress out for the potential expert. They're paid for the work they're going to do, right? So they just give an honest to God opinion, all right? And not taking every possible thing in the doctor's, giving the doctor the benefit of the doubt, all right? It's just looking at the case straight, all right? But that retainer issue helps relieve people of having to worry about getting paid. It's set. And then it helps make it, you know, you'll have integrity with whatever that opinion is.
Lisa,
And you really are valuable to the profession. Sorry, go ahead, Arlen.
it may be hard for people in Pakistan or other countries that are viewing this to put this conversation in context, because the United States is a very different place than Pakistan.
For sure.
But that having been said, and it'd be interesting to know how this is handled in Pakistan, but we don't have time for that, maybe a future program. So to this point, how much should a doctor charge to be an expert witness?
Yeah, it really is based on experience. All right. And so, I mean, I see things from $400 an hour to $2,000 an hour. And that $2,000 an hour was 15 years ago. Okay, for a neurosurgeon who thought a lot of himself. All right, the problem was the $2,000 an hour guys never read everything. Okay, they gloss over stuff. So I know anybody that's way up there in the stratosphere per hour, that's going to be a problem because they're not going to do the work. The $400 an hour person, which is usually an internist, okay, or somebody fairly early in their career, I know that's going to go up. The cost for review is commonly lower, all right, than the cost for testifying, because it really is painful, okay? Unless you grew up with lawyers in your family and you've been arguing your whole life, okay, it can be kind of painful to be cross-examined for your opinion, all right? You know, I rarely see anything under $450 now. And we really don't see things over $1,000 an hour. So it's usually in that range, and it has to do with specialty, and it kind of ties into what you get paid to do for real for your regular job.
And is it the same for, Junaid asked, is it the same for consultation as being an expert witness?
So the review, yes. What we pay for review, yes. I can tell you most of us don't want to use consultants because we have to do the work twice. It's a little different if it's in your area. A very, very well-known general surgeon here in town was my consultant for about 10 years. All right, because he knew what was really going on. He knew who the problem children were, and he could tell me things. And I protected that relationship with him, but it was only because he was here and he knew all the players. And he would never testify here because it would hurt his reputation.
As it turned out, the median compensation is right around 500, 550. And if you're in a subspecialty, especially the surgical subspecialties, and especially the ones with not a lot of subspecialists in that domain, and the years of experience, so 2 years with one deposition behind you versus 35 years with 100 or 200, that's a totally different range, I think. So I'm going to circle back to my original question, and I love the discussion, but why would a doctor enjoy this work? I think that was my question in terms of what's good about this line of work for clinicians from the lawyer perspective, and I can comment on it from the doctor's perspective, and also what's not so good, you think, for a doctor to take on this line of work?
Sure. I think what I see from the physicians that I work with, that what they really appreciate about this job is that they're helping patients in a different way.
Yeah.
They're helping patients that have been wronged, and by something only they know how to explain. All right. So it's like being a doctor, except it's in a different realm for that patient. And so I hear very, very positive things from my experts about being involved in these cases because they're helping people.
Yeah.
The not doing thing is if somebody is, I think that it's a surprise how hard cross-examination is for a lot of doctors. Okay, they're not used to being questioned right in their face since they were residents. Okay, and like Anthony and I had a case together where I had like the best guy in the world, famous, at a very famous children's hospital. Nobody like tells him every single thing you just said to me is wrong. Why would you ever tell me that? You know, doctor, you must be an idiot. Okay.
Yeah.
No one talks to him like that. Yeah. He's not used to that.
Yeah.
Okay. But that, which is always a challenge with those guys if they're going to testify, because that's how it is.
Yeah. No, the good news is that, Lisa, I really think in the last 20 years that the opposing counsel have been a lot less hostile as a group than I would say in the 90s. It was, I mean, had personal insults. I mean, it was a free-for-all. But I think something happened in the early 2000s. I don't know if you had meetings and you all talked about it, whatever. Let's be nicer to doctors, whatever. But it was a clear change in the attitude, and sometimes almost over polite. And you wonder, like, what's going on here? It's a psychological game, right? That if I think lawyers feel like sometimes, I bet that if you're nicer, you can get more traction on your side of the argument. And I think just to add to what you said, which are really great comments, I think what's good about being in this line of work is, first of all, you get some just more general knowledge about, you know, the medical legal framework, particularly in the US, and gets very convoluted. And I think also you become a better clinician because you know, essentially learning from other people's mistakes and getting paid for it. So that's kind of a nice a combination of things, and just learn to be a better clinician. And that's how my mentor 35 years ago convinced me to pick up my first case, is you'll be a better doctor doing this line of works. And he was absolutely right. I think that not so good, in addition to dealing with lawyers that can become hostile, is sometimes you're faced with perhaps a clinician in your subspecialty that you have heard of, or you know even, or have met at meetings, and that's a little uncomfortable if you're on the plaintiff side. And that's additional stress on top of everything. So, and you may or may not even get a reputation for going against doctors. So that's something that you'll have to decide. But overall, wouldn't you say, Lisa, it's good to do both sides, defense and plaintiff work, because then the other side is not going to jump on you for doing almost all on one side versus the other.
Sure. I mean, there are very, very few of us that specialize in this area. And so what that means is sometimes someone will see a bad outcome that doesn't do this kind of work when there's no case. All right. And so they just want to bring the case because it looks like a big loss.
Yeah.
And they don't know they don't have a case. All right, so you get involved and you defend those cases, that helps your credibility. You know, I mean, you're doing the right thing. You have integrity in that, and you're actually upholding the standard of care. All right, so that's why, yeah, both cases, but don't do defense work or plaintiff's work just to build a resume. All right, because then it's really a slippery slope to just telling people what they want to hear. It doesn't work for any of us. Remember, the plaintiff side of the case, we pick our cases. All right, we cannot stay in business if we're constantly picking cases that we're wrong in.
Right.
All right, the defense side of the case, they have been hired by an insurance company to defend a case regardless of what happened. All right, so but there'll always be defense cases. There'll always be cases that shouldn't be brought by people who don't know what they're doing.
If I could interlude, just to make, again, a couple of points. One is, a question was asked, so if you agree to be an expert, what then happens? The short answer is you're going to be fairly extensively prepped by the lawyer. And I put in the chat that at one point I was locked in a hotel room with 4 lawyers being prepped, depending on the significance of the case. I mean, some of these, we're talking about multi-million-dollar settlements, so there's a lot on the line. Number 2 is if you agree to be an expert or consider being an expert, sometimes your worst enemy are your own words. In other words, if you're a key opinion leader, you've written a lot of stuff, I can tell you that the defense lawyer in a plaintiff's case will read every single word of every single thing you've ever written, and they're going to hold it against you. Well, doctor, didn't in blah, 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 didn't you say, and now you're saying something different. So you have to sort of review all that stuff and understand the context of what you're saying. The other final, to Anthony's question, what's the downside of doing this? It can hurt your own reputation and you can become a target. And by a target, I mean by your colleagues, as Anthony alluded to, but more specifically, possibly by the organization that you work for. So if you are an employed physician, for example, at an academic medical center, like I was, if you agree to testify, there's a whole lot of rules and regulations about what you can do, what you can't do, who you can get involved with. In my particular case, it had to do with tobacco litigation. And that was a real hot button. And I had to make a serious decision about whether this was something I wanted to participate in because of all the issues. So I mean, there's a lot of caveats to doing this. And sometimes it just comes back to bite you. So this is a great discussion considering the pros and cons, and you just have to do the cost benefit.
I think the benefits outweigh the downside, because I think the personal gain from being a better clinician and learning the mistakes that other people have made is a really, really important one. As I said, the good news is that lawyers are a lot less hostile as a group than 20, 30 years ago. I want to get back also to a couple of sort of nuances here. I work with Lisa for probably about 10 years now, so we understand each other. And one of the things that she and I always talk about is to be the best expert witness I can be for her, I will actually turn the table around, which is not something people do very often. So some will ask, someone like Lisa and say, tell me about the opposing lawyer that I'm going to face during a deposition, or particularly the trial. But most don't. And I want to know everything about that lawyer that Lisa can tell me, so I know the personality, the way the questioning goes, past depositions I can read and understand the line of questioning. So that's a very good sort of an advantage you can gain. But even more than that, I'll ask Lisa, and she'll giggle if I said this, but I'll say, pretend you're on the other side, come after me, with your best, toughest questions, which I'm amazed that most witnesses actually, and you can tell me right or wrong, most witnesses don't do that, because I want to turn the table around and say, Lisa, ask me the toughest questions you would ask if you were on the other side, and I will also pretend I'm on the other side as the expert witness and come up with the toughest nuances in this case that you and your expert witness will have to, counter. So it's good to kind of do 360 on the whole case, look at what the other expert witness might say and think if you're hired by the other side, and also have your lawyer friend on your side to pretend he or she's on the other side and come after you with tough questions. And then find that, and Lisa's very good. So by the time I'm done with Lisa's tough questions, the opposing counsel is rarely, I think, tougher than what she's come up with in terms of questions. And the prepping part also assumes that you've done your prep work, because there's nothing worse, I'm sure, for Lisa than an expert that hasn't really prepared enough on the medical side of the case and gets, and sometimes the lawyers can get amazingly detailed and granular about what they ask you, like what's the pH of the second blood gas, after 10 o'clock. And I always like to be over prepared, because then if you can answer that question, you can see, their facial expression is that, okay, this guy's really prepared. And then he or she's in for a tougher, deposition or trial. So I think being over prepared is a good thing. And we talked about fees and quick words about cancellation. Don't giggle, because we've had a few. Cancellation and what do you do with those? And we talked about having the retainer, but just on the practical side, how do we deal with cancellations? How should a clinician deal with cancellations? Because that happens a lot in this work.
It does. It happens a lot because trial attorneys, we never know when we're going to get called to trial. It's really bad in California. And so we can get called and everything gets taken off. Some people have rules about that. If you cancel within the first week, then you have to pay some part of it. It really has to do with your practice. If you can recoup that time and do something else, do something else. Okay, but if it's really close in time, then put in your fee agreement that you're going to charge X amount of money if you cancel within 24 hours or something. Okay, that part is important. I want to give one little asterisk to something that Anthony said. Anthony doesn't get hammered because anymore. One, because he's very experienced and he knows how to stay calm when he's talking as an expert witness under cross-examination, but he tells the truth. I can tell you, like I started this out, I have a bunch of kids. I am a mama bear. If someone is lying to me in deposition to hurt my client, that cross-examination is very painful for them. All right, so that part about having integrity when you make your decisions, there's a guy out there, Radetzky, testifies only against children who have severe brain damage or died from infectious diseases. He has been followed by investigators because he lies about what he did the day before. 400 of his depots only for the defense have been wheeled into the courtroom to show that he does not testify for plaintiffs. I mean, we do our homework about things. And so that's why I think the integrity piece is why Anthony does so well on his cross-examinations. But yeah, it is really painful if you're not doing the right thing. And so you want to do that work at the beginning, not kind of get caught up in the case and end up in a place where you're having to give a deposition that you don't believe in.
Another nuance, Lisa, and you and I have the strategy is sometimes I'll tell Lisa on the medical side, I'm going to have to give the other side this one just so the integrity is maintained. And then, but we'll win the war. It's like we'll lose a battle to win the war. And I think that's something that I've learned that, if you really can't defend something or you really can't go against something, then, I think in depositions look so much better when you just admit a small defeat, but still come out ahead. And I think when you're absolutely resistant that everything the other side is asking you, then in terms of telling, exactly what happened in your opinion, then that's a downside eventually, because that will come back to haunt you, especially in a court if the case goes to court. Quick question, what % of cases get settled these days?
Oh my gosh, 85%.
Yeah.
85%.
Yeah.
We try more cases in the medical malpractice realm than other kinds of tort cases.
Yeah.
Okay. I mean, I try about three cases a year. That's a lot. Okay. But I think life is worth a lot. And so I go to trial to get those outcomes for my client. But yeah, most cases settle by and large. Caps have a lot to do, believe it or not, with cases not settling. All right, people think that caps are better for them, but in reality, it means that we try a lot more cases to get, guess what? Punitive damages against the doctor or the medical system. All right, because punitives aren't capped almost anywhere. All right, punitive damages. And so that's why I mean, caps are bad for whole lots of reasons, but one of the things is it has a much better chance of driving a case to trial if somebody gets into trouble, because the insurance company doesn't want to pay the cap because it's the most. So I'm trying a number of cap cases this year.
And a few quick definitions for clinicians who may or may not do this work. Standard of care.
Yeah, standard of care is what a reasonably well-trained physician in essentially the same specialty would do under the same or similar circumstances.
And
okay,
usually,
so it's well-trained, not the average.
Yeah.
Okay, it's a well-trained doctor.
And within a reasonable degree of medical probability, which I'm
Yeah,
saying so easily now.
I know. And you notice how fast Anthony said that little phrase out? It is really tough sometimes for doctors to understand that we are in a preponderance of evidence proof, burden of proof. It's, like you have reasonable doubt in criminal cases. We have preponderance of the evidence. Okay, so what it means in preponderance of the evidence, reasonable medical probability means it's more likely true than not. Right? People have trouble with this standard sometimes. That's 51% chance the patient died from malpractice. That's the standard. And so if the plaintiff's lawyer meets that standard, it's more likely the patient died from malpractice, the patient wins. Okay, so that's the standard. Now, we could talk forever about why that's that instead of beyond a reasonable doubt. It's your freedom versus money. Okay, but yeah, those things. Standard of care is not what your hospital says is a standard. It's a national standard.
Yeah.
Okay, what a reasonably well-trained physician in the same or similar circumstances would do nationally. I want to give one example about this because I think it's really important. I had a general surgeon here that testified that you had to give heparin, breach of standard of care, not to give heparin following an appendectomy. General surgeons hated giving anticoagulant medication following surgery because people would bleed. All right, but there are lots of articles, memos from their own, from the American College of Surgeons saying you need to give anticoagulant medication to people after surgery. But most general surgeons wouldn't do it. My general surgery expert testified, I know general surgeons don't want to do it. I know they're fighting it. I haven't done it at times. I breach the standard of care because the standard of care is that we should be giving heparin to patients because we have to go in more often and take care of bleeding. We don't like that. But people don't die from bleeding in a hospital. People die from pulmonary embolus in a hospital. All right. So it was standard of care is really what you should be doing. What everybody understands you should be doing, but it's not what everybody does all the time. Okay. So it can be complicated, especially when you're young and you're just learning all those things.
Lisa, one of our attendees, Janae, is asking a question. Does settlement become an issue on the physician in the future in terms of credentialing and licensing?
Yes. That's the reason why our cases are fought so hard, Janae. All right, is that the doctors know there's going to be an impact on them. They'll get reported to the National Practitioner Data Bank. And they'll get reported for what happened and what the amount was. All right, so anything under $70,000 does not get reported. I don't think that number's changed. It was $70,000. Everything over that gets reported, and it does affect malpractice insurance rates, has to be reported to the state board, has to be reported during credentialing. And so, I always want to tell physicians, as long as you're doing your best job, you're working hard, you're doing what you think is absolutely right, and you don't, frankly, let the medical corporation shove you around so that you're not doing your job. as long as you do your best job, you will be fine.
Yeah.
If you make a mistake and you take responsibility for it, you're probably never going to be sued about it. All right. But if you're in a divorce and your head's not in the game, okay, or you have a drug problem, you're drinking too much, you're too old to be doing your job, or you're in over your head and you don't ask for help, those are the places that people get in trouble.
Sometimes also one of your partners is getting sued or is taking the brunt of something, and you're in the group. So that's what happened to me, as I was in a group. So you're going to get named especially if you're involved in the care of the patient, even if it's peripheral. So, and sometimes physicians in that category take it very personally, like I did everything perfect and everything. And it's not personal. This is not a personal thing. This is against, someone trying to get justification for the system.
Right.
Anthony,
and-
I
yeah.
disagree with that. This is very personal. And I'm sorry, but when you get sued, you take it personally.
No, you took it in the wrong context, Arlen. I meant this is not directed at you as a physician. This is when you're named as part of a bigger group. So
Right.
that's what I meant. Not like, of course we take it personally, but what I meant was,
Right.
This is not directed at you. This is directed at a partner in your group. And it's
Right.
not personal in the sense that you're not the main person being named. That's what I meant. Yeah.
But even when that happens, and it's happened to me, just like it's happened to you, we're all human beings, and we're all trying to do the best we can, with some exceptions. I mean, there are jerks and people that are dishonest, but if you're trying, even when you're trying to do the best you can, and that happens, in my personal case, I took it pretty personally. Now, I tried not to act out and be a jerk. And in fact, a frequent strategy is to pit one doctor against another. So I'll give you an example. I had a patient who we did surgery on that died in the ICU. Was it the fault of the anesthesiologist in the recovery room? Was it the fault of me? Was it the fault of the respiratory? There's 17 people, as you well know, everyone sort of gets named. So a strategy employed typically is to pit one doctor against another, and that gets pretty personal. Secondly, to Junaid's question about settling, if you work for an organization, I'll give you another example. When I was working at the VA, something happened, filed suit, and it was settled. I had no say in whether the case was going to be settled or not. I was an employee of the US government. And in fact, the case was so-and-so versus William Jefferson Clinton. They didn't sue me. They sued the President of the United States because I was working at the VA. I had no say in whether the case was going to be settled or not. They settled it, and I wound up on the National Practitioner Data Bank. Now, the fact of the matter is, as I indicated, a third to a half of doctors will be sued during their career. So it's kind of just part, at these days, it seems like it's part of being a doctor. Did it influence my reappointment on the medical staff? No. Did it have an impact on whether I could practice medicine in the future? No. So, but there are issues. And I'm wondering whether
surprised
Lisa,
it's only 34%. I'm a little surprised based on, I think just about all of my colleagues have been sued at least once. But I think, isn't there a timeline, Lisa, that it's 8 to 10 years, right? You don't have to, for staff privileges and credentialing, I think it's only 8 to 10 years limit. So they're not gonna question a case necessarily or want more details if it's like 25 years ago, right? So
yeah, so let me give you a little secret about things too, about this concept of the National Practitioner Data Bank, okay? What's important about it, like if you step in, I said my husband's a defense lawyer, right? If you step in and say, okay, I screwed up, shouldn't have been at work that day, I took an Ambien the night before, I was really out of it, you ought to settle this case. You get in and you get something done and it gets settled fast, it's gonna be much cheaper.
yeah.
Right, then 3 years later, after all the expenses have come in, all right, and everybody has fought, that settlement 3 years later is going to be much higher. But if you don't settle a case where you made a mistake and it goes to trial, your potential for a huge verdict, okay, because the verdict is what's going to get reported, not what it got knocked down to under the cap. Okay, I mean, what that verdict was will get reported to the National Practitioner Data Bank. And so that's worse. I do a lot of credentialing cases, people that aren't qualified to be doing the work they're doing. And if I can get to, if I get that National Practitioner Data Bank and it shows that people have got hits for $2 million multiple times, then that's not somebody that's employable in a good institution. So it's complicated, you know, when you settle and when you don't. It's very hard to win a malpractice lawsuit for the plaintiff. It is. Okay. We lose cases where everything was done wrong by the defense. The defense will get out of it sometimes. Okay. But if something was done wrong and they're just running it up the flagpole and a big verdict goes against that doctor, it shows the doctor's not willing to be responsible for his errors. Okay. And I see that in credentialing cases. When cases go to trial that should never have gone to trial because they won't settle. So that one thing I think is important.
Also, for those of you who are interested in this line of work, a couple of hints, and Lisa can comment also. When you do get the records, first of all, should you get it digitally or in hard copy?
It is totally dependent on who you are as a human. Okay, I mean, I have to read things in paper. A lot of people want them digitally. I send a full-blown medical chronology with every single one of my cases that my nurse practitioner did. Okay, so that you can see what happened in what order.
Yeah.
Yeah, but whatever works for you. I believe, I want to tell you this before we end, that something Anthony does, and I think it's very important, skilled experts do this. They write out a synopsis of what their opinions are going to be on the day they're going to be deposed. When they have to give those opinions, they write a synopsis, all right? Because a defense lawyer or the other lawyer will follow your outline, all right? So you can control what happens in the deposition. And then you also don't make any mistakes. Like you didn't forget to talk about something because you wrote your own notes. The old idea of telling doctors don't write notes when you're an expert is antiquated. Writing notes for what you want to say in deposition is a really good outline for doing a good job in a deposition, no matter what.
Also, I find it helpful if you're getting more than, starting to build your number of cases, it's good to stay extremely well organized, have everything in Dropbox, all the letters, invoices and everything, so that when you get busier, it's not going to be a mess. And it's really takes a lot of discipline to stay organized. And if you're interested in this line of work, set aside a certain time of the week to do this, because otherwise you're always going to be behind. And I know Lisa and I talk about this all the time. As a clinician, you'll build your practice in this area if you underpromise and overdeliver. Like I try to tell my legal friends that I'll try to review the cases in 24 to 48 hours and I'll get back to them. And now the downside is you get more cases because they like that turnaround. They almost never get that turnaround. But as you're building the practice, it's a nice gesture to the legal counsel that you're available and you're accessible and you get the work done in a timely fashion. So we only have a minute here. Last words of wisdom, Lisa, from your perspective for clinicians, not necessarily in doing medical legal work, but just as clinicians.
Sure. I just want to tell you that patients really, really appreciate physicians that, being a good person can make you a good doctor. Having integrity in your regular work will keep you out of trouble. Your patients will think more highly of you. It will keep you from getting sued. And if you choose to do this work, then you're helping patients in a different way. And so I love and admire my experts that are willing to do this work for patients. And I really appreciate that all of you care enough to be here today. So it's nice to see all of you. Thank you.
Thank you, Lisa. Arlen, you want to take us home with any comments before we close?
No, just thanks very much for the information. There's obviously a lot to this, and the sort of the nuts and bolts of how you do it, how do you get involved, and we really didn't discuss other opportunities other in medical legal issues, for example, in product liability and all that other business. But and Junaid brought up a good point of what about telemedicine? What about artificial intelligence? What about shiny new objects? So if that's something that you would like us to address, we're happy to do that and set up a program. So thanks very much for joining us, and hopefully we'll see you at future events. Have a good
Hi,
weekend.
everybody.
Have a
Thank
great
you,
day.
Lisa.
Nice to meet all of you. Take
Nice
care,
to meet you
Anthony.
as well.
See you soon.